with our son with Free Alabama Movement. We're continuing on with our justice series, Fight for Justice, exposing the Alabama criminal justice system, particular laws within the system that are being used in a racially discriminatory manner, targeting the African American community disproportionately, and particularly African American men. I have with me today a brother by the name of OEATHA, ARCHIE. I'm going to allow him to introduce himself. He's going to tell you our worries from, what his circumstances are, and what we're trying to, and we're going to get into some facts about his case and what we're trying to do today.
My name is OEATHA ARCHIE III. I'm from Birmingham, Jefferson County. I was convicted in 1994 of drive-by shooting.
Okay, so 1994, we had talked about this was back during the gang-banging era. They were passing laws. The crack law was coming into effect, and they were starting the war on drugs, and they were passing all these laws, and we know that the net result that a lot of black men was incarcerated. Do you remember that time back then? What do you remember about it when you think about that?
Well, back then, you know, it was a part. We was in low income neighborhoods. You know, it was a lot of crime rate going on, and it was a lot of things going on back at that time. Like you said, it was a lot of gang activities going on, and a lot of people, you know, they was convicted of crime that had nothing to do with gang activity at that time.
And so when you say gang activity, I'm glad you brought that point out, because that's part of the story in your case. It's part of the backdrop of why you were even charged in the first place. You were charged with under a statute that prosecutes gang-related drive-by shootings. That's correct?
That's correct.
And what year was that statute passed? Do you remember?
Yes, in 1992.
So in 1992 it was passed, and right after that, that's when you were prosecuted under. So
yes, 2 years after that.
Okay, so just to give y'all a little backdrop, he was prosecuted. What happened was the Alabama legislator moved to address gang-related drive-by shootings in the state of Alabama. These issues were going on around the country at this time. It was being popularized and glamorized on TV, rap music, and whatnot. And people were getting in vehicles, driving by, shooting out vehicles, killing people, or catching people in their vehicles, rolling up on them, killing them and stuff. And in certain instances, you had children being killed. You know, stray bullets were killing innocent little kids sitting on the porch, riding on bicycles, walking down the street, standing on the sidewalk, ice cream stand, all that. So the Alabama legislator declared that a public outrage, and they wanted to address it. And so they passed these laws where they amended the Alabama capital murder statute. What were the particular statutes that they amended to the statute? We got the capital murder statute right here to talk about these particular statutes, Mr. Archie.
Okay, 17 was 13854017 was when you shoot out of a vehicle.
Okay.
And 18 is where you shoot out a vehicle into another vehicle.
Okay. All right. So what they did was, but what the legislator said, we don't have the legislative minutes in this series, but in part one of the series, our other video dealing with this, we have the legislative records, we have the minutes. You got some of it there?
Yeah.
And they specifically said that they were going to address gang-related drive-by shootings. And so we're going to get up to this document here in a minute. This is a joint House resolution, and we're going to get to that in just a minute. But so they said that if you use a vehicle to commit a crime and it's gang-related, then it's a capital offense. So he was prosecuted under that. So which statute were you prosecuted under?
Under 17.
Under Title 17. Title 17, murder committed by or through the use of a deadly weapon while the victim is in a vehicle. So that's what Mr. Archie was charged with. And we're going to talk a little bit about his case. And the thing about his case that were one of the areas where the injustice occurred is that these laws specifically were passed to address gang-related drive activities, but the application of them were almost exclusively to black men. So you were charged with this crime. We're gonna talk about. Let's talk about the history of how this law has been enforced. We know about the Shirley. What is her name?
Shirley Henson.
Tell them about Shirley Henson. Let's talk about that.
Well, Shirley Henson was a middle-class white woman, and at the time of her case, she was with this lady named Miss Foster. She was They was traveling on the highway in Jefferson, Alabama, and Shirley Henson was trailing Miss Foster, bumping her car at the time of the situation. And Miss Foster, she got out her car to confront Miss Henson, and Miss Henson shot Miss Foster in the face.
Okay, so that was a murder while the shooter was inside of the vehicle and shot outside of the car and killed the vehicle. That would be a violation of
17.
Okay. No, that would be 18. Yeah, murder committed by these there 5 otherwise within or from a vehicle. But she wasn't charged with capital murder. What was she charged with?
She was charged with road rage.
She was charged with road rage. So we have another case. Here's another white man. His name is Griffin. Jody Edwin Griffin. Tell him about Mr. Griffin.
Mr. Griffin was he had an issue with his fiance and her ex-husband. They had some children involved with this case, and they was into it about these children, and he committed the crime. I mean, he shot the dude over the children.
Yeah, they were meeting in a parking lot
yeah,
to transfer the child from the mother back to the father.
Yeah.
And Mr. Griffin was now dating the mother. He was inside the vehicle, and when the father pulled up, he pulled out a gun, fired it out of the vehicle, and killed the man.
Yes.
He was charged with capital murder, I think, but he was ultimately convicted of a lesser included offense. Is that correct?
Yes.
All right, so here's another instance, another case. Guy receives a life sentence, 20 years. There was another white man. His house was broken into down in the Mobile area, and the people who had broken into his house was driving away. And he saw him driving away and came out with a high-powered rifle and shot down the street and killed the man.
He was coming home and saw a car pull out of the driveway. Unbeknownst to Bedgood, the guy that was pulling out of the driveway and stealing out of his garage. So when Bedgood realized that it was somebody stealing from him, he jumped out of his car and the dude pulled off. Dude got a half a mile down the road almost. Bedgood pulled a high-powered rifle and shot 5 or 6 shots into the guy's car, shooting him in the back of the head and killing him. Bedgood was initially charged with manslaughter, never charged with murder or nothing. He was charged with manslaughter.
And what color is Bedgood?
Bedgood was a white guy. Out of Mobile County, and he was charged with manslaughter. He received criminal negligence homicide. That was what he got convicted of. He got 6 months county jail, and that was it.
I think they suspended that because it said, but no jail time.
And no jail time, they suspended.
Cases that highlight the fact that this gang-related drive-by murder statute was disproportionately used to target black people. The problem is, he was not the person who actually committed this crime. He's scientifically, factually, actually innocent, whatever you want to talk about. So the first thing we want to do is just set you up to get you to understand what type of law he was prosecuted under, and to show that there is a racial disparity in the way that this law is actually enforced. And so now we're going to get into the actual facts of his case. All right. So you were charged with murder. They're saying that the victim is saying that there were 2 people in the vehicle.
Yeah.
All right. You have 2 people in the vehicle, and then you have another vehicle over here. So the 2 people in this vehicle are the vehicle, the driver was shot and the passenger was shot. Okay, and they're saying that you're the person that fired into their vehicle and killed this man. Okay. One of the things we know about the case is that the victim was 6'4". He was 6'4" tall. You had an autopsy report. Pull that autopsy report out. Let's look at one. And this is important. This is the victim. This is the person who actually died. He was sitting on the passenger side of the car, and this is the actual autopsy report from the Alabama Department of Forensic, Jefferson County Coroner's Office, and yeah, here's the details on the gentleman that was killed. He was 76 inches tall. You see it right there, 76.5 inches tall, 6'4.5", and he was sitting in the passenger side. And so while he's sitting in the passenger side, they're saying that they were sitting at a stoplight and a car pulled up and fired shots into the vehicle. So the driver, he got shot, and the passenger got shot. Okay, they're saying that Mr. Archie's shots are the shots that killed the passenger. Okay, so the first thing we want to do is get this statement. This is the a newspaper article that was published in the Birmingham News, and this is I'm gonna read from this article. You can see it here is August 8, 1988. I'm gonna read from this article. This is a statement from the prosecutor. Right, I'm gonna read this paragraph and this paragraph. I'm gonna give you a good close-up of it so you can see it yourself for a minute. And I'm gonna start right here and read down. It says, a capital offense usually carries the penalty of either life without parole or death. Laura Petro, who prosecuted the case, said the death penalty for Archie wasn't an option because there were no aggravating circumstances. Remember, what this capital murder statute was all about, the aggravating circumstances are that you must be gang-related and that the vehicle was used as an instrumentality of the crime. So the prosecutor is already admitting that those aggravating circumstances don't even exist, yet he was charged under the statute anyway. She said she was pleased with the verdict, although she had worried that jurors might stumble over the fact that Murray was shot in the left side. All right. Jones was driving Murray's white Chevrolet Impala, and Murray was in the passenger seat when another car pulled up to the right side at the traffic light in 1300 block. And then it says, Miss Petro said Murray could have turned his body to try to escape the bullets, at least 8 of them that Archie fired into the car. But she said the testimony of Jones, who survived and drove the two, provide the key evidence. Okay, so they're saying that a car pulled up on that side and fired in this direction to kill the man. All right. First thing is, remember the guy was 6'4". Describe to him what they're looking at right now.
This is the sweater where the victim was shot from the left side to the right side.
Okay. Now, what he's saying, okay, this is the entrance. This will be the entrance wound right here. And these are the 2 exit wounds on the right. Okay. There is no disputing the fact that the bullets entered on the left side. Okay. So what this evidence shows is that the victim was shot from this side, and the bullet traveled that way and exited out. Just the way it's depicted. So the bullet traveled that way. But they're saying that Mr. Archie pulled up over there and fired this way. But this shirt shows that the bullets traveled in that trajectory. So that's the reason why the prosecutor said that she was worried she was pleased with the verdict, although she worried that jurors might stumble over the fact. That's the highlighted part. That's where she's acknowledging the fact. So the way that she's trying to explain this is by saying that this 6'4" man, she said, Ms. Petro said Murray could have turned his body to try to escape the bullets. That's right here. That's right here. So she's trying to say that the victim turned around. So instead of the bullet being fired from the driver, they're saying that it went this way, which the evidence shows that it went this way. They're trying to say that the guy turned around. So show them what she's trying to say happened.
She's trying to say a 6'4" and a half dude turned around and got up under the car.
Go ahead and get all the way up under there. Just show them exactly what.
Get up under the car. Get up under the car. Like this.
Like that. And that the bullets Mr. Archie file allegedly came in that way. That's how it came in. Okay. So the first thing is, if she's saying that he turned around and bent down, then were there gunshot wounds on the side of the door or anything showing how that could have transferred? Well, you have pictures of the vehicle. Be mindful of something. Mr. Archie has always maintained his innocence, and I emphasize that because the car that they say he was in, they impounded it. No gunpowder residue, no gunshots, no shell casings, not even bullet wounds where the car was being fired on, and we have proof that the driver of the vehicle or someone inside of the vehicle where the person was killed was firing a weapon also. So we're going to get to that, but he's looking for the exhibit for the vehicle that the deceased was in to see if this lines up with the testimony of the prosecutor side of the vehicle. Now she said that they testified that Archie's car pulled up beside this car and unloaded on him. But you look at the car, the window is not shot out on the passenger side, no gunshot holes on the passenger side. There's no proof that what they're saying is true regarding they're saying this man pulled up and shot. But when we look at the evidence, we can see that the person that actually killed this man was in the car with him, and that they weren't even in a shootout. As far as the evidence goes, we can't say exactly what happened, but we can say that based on this evidence, the man who he was in the car with is the one that shot him and killed him. This is another piece of evidence. This is the blood. And y'all can see that the blood is in the center of the seat. It's in the center, which means that it's just like this. This is the image. If this man was shot right here, then the blood will leak out right here, just like you seeing in this video. Just the middle of the seat. So these are the facts that we're trying to prove, that this is not only is he been racially profiled and racially charged, but he's also been wrongfully convicted. They use a racially discriminatory law to prosecute him, and then they just made it up. She said, Ms. Petro said Mary could have turned his body to try to escape the bullets, at least 8 of them, that Archie fired into the car. But she said the testimony of Jones provided key witness. There's no proof of that. There's no proof of that. The proof shows that this man was shot by the driver of the vehicle, who was a state witness and testified against Mr. Archie and got him convicted of a life without parole sentence on a capital offense. Immediately after the gang-related drive-by shooting statute was passed, enacted, not even alleging that it was a drive-by shooting. That takes us to the House Joint Resolution, House Joint Resolution 575, which was passed, March 28, 2006. And so I'm going to read the House Joint Resolution to you so you can get an understanding of what this is and what we're talking about with this law. Enrolled House Joint Resolution stating the legislative intent concerning the interpretation of subdivision 18 of section 13A540 of the drive-by capital murder shooting statute. Whereas in the early 1990s, there was a public outcry against so-called drive-by shootings that were murder committed by or through the use of a deadly weapon fired or otherwise used within or from a vehicle, which murders were gang-related or intended to incite public terror or alarm. And whereas in response to the foregoing concerns, the legislature in 1992 passed Act 92-601 of the 1992 regular session, amending 13A540 to, among other things, add a subdivision 18. They also added 17, 18, was 17, 18, and 19? Or 16?
17, 18.
17, 18, to make murder committed by or through the use of a deadly weapon fired or otherwise used within or from a vehicle a capital offense. Whereas Section 13A540 has been interpreted by prosecutors and the court to apply to murders committed by or through the use of deadly weapon fired or otherwise used within or from within, even if the fact of that murder weapon was fired from within was not related to the commission of the offense, and the murder was not gang related. They found out that the prosecutors were using it even when the murder was not gang related. And whereas the legislator is aware of the case of State of Alabama versus Fondren, Calhoun County, CC 02600, in which Fondren was convicted of capital murder for violating Section 18 because the victim was shot by Fondren while Fondren was in a vehicle, although there was no evidence that the motor vehicle was an instrumentality or otherwise involved in the shooting, or that the shooting was gang related, which is what the legislator said these laws were passed for. In this case, the victim approached the defendant's vehicle while the defendant was parked. The fact that the defendant was sitting in his vehicle was in no way related to the commission of the offense. Now, therefore, be it resolved by the legislator, both houses thereof concur, that in passing Act 92-601, it was the intent of the legislator in adding subdivision 18 to 13A540 was that the provision would apply only to murders committed by or through the use of a deadly weapon fired or otherwise used within or from a vehicle if the motor vehicle was in some manner an instrumentality or otherwise involved in the murder. Be it further resolved that the legislator urges the Attorney General and District Attorneys to charge with violating said only those individuals who commit murder by or through the use of a deadly weapon fired or otherwise used within or from a vehicle as provided above, which is when it is gang-related drive-by shooting. Therefore, be it resolved that the legislator urges the Court of Criminal Appeals or the Alabama Supreme Court or both to review at the earliest opportunity the interpretation of 13A540 and hold that it applies only to those individuals who commit murder by or through the use of a deadly weapon fired or otherwise used within or from a vehicle if the vehicle is an instrumentality or otherwise involved in a murder. This is the gang-related drive-by statute. Signed by this is a resolution that was signed by the governor at the time, Bob Riley. All right. After that, we have another issue in the case. The ballistics. If you all been following my YouTube channel, Free Alabama Movement, you know that I also have a ballistics issue in my case.